Okay, what are you on today? You're slurring your words. Well, yeah, you
Probation
are.
was supposed to be his second chance. Instead, it became the stage for one of the most jaw-dropping courtroom exchanges of the year. A man slurring his words in front of a judge, claiming he hadn't been drinking, then uttering a line so absurd it would later go viral. What he said next would unravel months of lies in seconds. But the real question isn't what he said, it's what the judge already knew before he opened his mouth. This case began 5 months earlier when the defendant was sentenced to probation instead of jail.
Well, yeah, you are. I'm listening to it. I'll just remind you, you were sentenced in February. You didn't start working till May. You could have had most of this done by now. At this
Probation
point,
is a conditional release. The court trades incarceration for a strict set of obligations: substance abuse treatment, regular drug testing, fines, work requirements. Violate those conditions and the court can revoke probation and impose the original jail sentence. It sounds simple. Show up, comply, stay clean. He did none of it. By the time he stood before the judge again, it was almost July. 5 months had passed, and according to the court record, he hadn't completed a single substance abuse class.
at this point, you're non-compliant in everything we told you to do. Treatment, testing.
I'm in testing.
Hold on. You're going to interrupt me?
He hadn't
Okay.
submitted documentation. He didn't even seem to understand the difference between treatment and testing. Two requirements he'd been ordered to fulfill since
All
February.
right, I'll give you that. Okay. All right. So you don't know the difference between treatment and testing.
Doctor, what the treatment?
Okay. What's your doctor doing?
Because I'm in mental health therapy.
Okay.
My psychiatrist.
Beautiful. Are they doing anything for substance abuse?
Yeah, they put me on medicine.
Okay.
And as the hearing opened, the judge noticed something else. The man was slurring his words in open court, on the record. "What are you on today?" the judge asked. Not "are you," but "what are you on?" The judge wasn't guessing, he was listening. This is where the case stopped being about paperwork and started being about credibility, and credibility in a courtroom is everything. A judge can forgive a missed class. A judge can work with someone struggling to find a job. What a judge cannot tolerate is being lied to in real time, to his face. That's not a technical violation. That's an attack on the integrity of the process itself. Here's something most people don't realize about probation hearings. The burden often shifts. Once a violation is alleged, the defendant typically has to show the court he's making genuine efforts to comply, not just promise to do better. Words don't satisfy a judge, documentation does, and he had none. Think about this in terms most of us understand. Imagine showing up late to work for the 5th time, and when your boss asks why, you say you'll try harder, with no plan, no explanation, nothing concrete. That excuse might buy you a day. It won't buy you 5 months. Courts operate the same way, except the stakes aren't a paycheck, they're your freedom. The defendant tried to redirect. He said he was working full-time, that he'd started a new job in May, so that he was doing good and trying
Are
to
you
survive.
working?
Yeah, I just started out.
Where do you work?
Server.
Full time?
Yeah.
When you say you just started, what do you mean?
May 26th.
Okay. And prior to that, how long had you been off work?
Long time. Like year. Probably like 2 years.
Okay.
On its
Yeah.
surface, that's sympathetic. Holding a job while on probation is genuinely difficult, and the judge didn't dismiss it outright. But then came the question that exposed the gap between his words and his actions. Did you bring us some money today?
Serving
He
is
hadn't.
really hard.
Okay. So you've been working since May. Did you bring us some money today then?
Not today because I have paid back rent.
Okay.
He said he would pay later. Promises again. No proof. Then the probation officer, call him the case's quiet enforcer, stepped in with a recommendation: 30 to 60
Okay.
days in jail.
I will be paying it off.
Ms. Trolley, what's your recommendation?
My recommendation is 30 to 60 days jail.
I'm the best here. I haven't had a job.
Okay.
This is where the
well,
hero of this story emerges, and it isn't the judge. It's the system working exactly as it's supposed to. The probation officer had nothing personal to gain by pushing for jail time. His job was to report facts, even unfavorable ones, even when the defendant pleaded that he had a job and deserved leniency. The officer held his ground. He told the court he'd given the defendant multiple chances, multiple resources, and that this wasn't even the first violation hearing. It was the third.
Are you willing to hold his hand and see if we can get him on track before next review?
I believe I have tried to do that. This is now his third violation of probation hearing. I've provided him on multiple occasions with resources on substance abuse treatment. I don't believe at this point that he's willing or able to comply.
That single fact reframes everything. This wasn't a first slip. This was a pattern, and patterns in legal proceedings carry far more weight than isolated mistakes. Now came the moment that would make this hearing unforgettable. The judge revealed something the defendant clearly didn't expect: a positive drug test from weeks earlier. He also tested positive on June 11th.
It is. He also did test positive for alcohol on June 11th.
Did you know that?
Did you know that? The defendant denied it, said he hadn't been drinking.
Did you know that?
No, I didn't know. They said 0.
So PBT, it was probably 0, but the urinalysis detected alcohol.
You
And
don't
then,
remember?
almost in the same breath, he said something nobody in that courtroom was prepared to hear: that he had been drinking. But he didn't taste it.
Then my go.
Okay, brother, you'll have to explain that. You'll have to explain that statement because it made no sense.
Drinks versus told me there's something in it, but I didn't taste it. I'm serious.
Read that again. He admitted to drinking while simultaneously denying it, all within a single, contradictory sentence. This is the kind of moment that becomes a courtroom clip shared thousands of times because it requires no commentary. The contradiction speaks entirely for itself. The judge's response was simple: "You'll have to explain that statement because it made no sense." It didn't.
I'm serious.
I know you are, and that's what scares me.
This is
Does
also
Mr.
where the legal stakes sharpen. A confirmed positive test, contradicted excuses, mistreatment, no payments, no documentation. Together, these don't just suggest noncompliance. They build what's legally considered a totality of violations, a pattern severe enough to justify full revocation rather than a warning. Judges aren't required to find one smoking gun. They're allowed to weigh the whole picture, and the picture got worse. The court reviewed his prior record, a previous DUI-related conviction from years earlier, and a separate charge for obstructing official duties. This wasn't a person navigating one rough patch. This was someone with a documented history of resisting accountability, now doing it again in real time in front of the one and person with the power to send him to jail. So here's a question worth sitting with when someone has been given chance after chance and still fails to comply. Does compassion mean offering one more opportunity, or does true accountability mean finally drawing the line? There's no clean answer. Reasonable people land in different places, and that tension is exactly why these moments spark such heated debate. The judge made his decision: 30 days in jail.
Too little, too late, Mr. Press. 30 days in jail. We're going to close your file unsuccessfully. One chance? You mean one more chance?
The probation file would be closed unsuccessfully, meaning the original case wouldn't simply continue under supervision. It would be treated as a failure of the entire probationary process. The defendant pleaded one final time, citing his job, asking for one more chance. The judge's response became the most quoted line of the entire hearing: "That's between you and your employer now."
Too little, too late, Mr. Press. 30 days in jail. We're going to close your file unsuccessfully. One chance? You mean one more chance? No. No. No.
My job.
That's between you and Ruby Tuesday.
Calm, final, no anger, no theatrics.
I'll just remind you, you were sentenced in February. You didn't start working till May. You could have had most of this done by now. Then you should have contacted probation. It's not your first rodeo. Goodbye.
Just
Goodbye.
consequence. And that's the partial, frustrating truth at the center of this case. Justice was served, but only in the narrowest sense. 30 days is a fraction of what the original recommendation called for. The deeper issues, addiction, unemployment history, mental health treatment that never addressed substance abuse, none of that was solved by a 30-day sentence. The system closed the file. It didn't necessarily close the underlying problem. That's the quiet frustration baked into so many probation revocations the paperwork resolves. The person often doesn't. What this case ultimately teaches is something far bigger than one courtroom. Authority, whether it's a judge, a boss, or an institution, earns trust not through power, but through consistency. And the moment someone under scrutiny is caught contradicting their own story, credibility collapses instantly, no matter how sympathetic their circumstances might be. Courts, like life, rarely punish a single mistake. They respond to patterns, and patterns eventually catch up with everyone. If this case stayed with you, let us know in the comments which courtroom hearing or legal case you want broken down next. Subscribe and share this video. Every share helps build a more informed, more accountable public at a time.